case. So, Mr. Gillett, we'd really like to know what
No
we've been
comment.
charged
I've
with.
told you no comment. Do not harass or stalk.
Ma'am, I'm asking you questions. I mean, Deputy Love says we've been charged with 22-15 or 21-5922.
Why are you lying about us in court? We don't have that medical stuff.
You
know
disclosed
it.
the medical records,
you
not
disclosed
us.
it yourself, Jill.
Is
that allowed,
that's a pretty
Jill?
serious
You
You
offense.
guys
just
should
lie.
not be filming
Why
in a
not?
judicial
Oh,
area.
I thought it was
We're-
There are rules not to
yeah,
film in
the court-
judicial
Yeah,
areas.
this is a
We're not in the
constitutional right
We're
that
like
you
right
guys
outside
down
the
here are gonna have
bathroom.
to understand.
I've told you I have no comment. If you don't stop following
We can
me, I
continue
will
to
charge
ask
you with
questions.
stalking.
You're
We
gonna charge
can
us with
continue to ask
stalking.
questions,
You're gonna
Jill.
charge us with
You lied
stalking.
about us in court. We'd like to know why.
Do
No,
not
no,
comment
no
on
charges
all
listed,
this.
huh? So you're actually investigating us? Are you ever gonna tell us if we're charged, or is this just a criminal trial that happens without any kind of oversight at all? You just rule it yourself? Do you often lie in court? Judging from what we're hearing, it does seem that that's the case. You gonna share it with us? If I give you an upload link, will you share that with us?
Do you guys have any other questions from?
I do. I'd like to know about that duck.
Thank you.
Did you kidnap a duck, Jill? I hear you kidnapped a duck and threw a fit inside your house when the police came to get it back for the owner. Is that true?
Jill, is this stalking? Is this stalking? Did you know that the stalking statute says that it doesn't apply when you're conducting official business, especially in public? If you were trying to charge us with some bullshit charges,
Yeah.
asking you about it, and you said, quote, I'm charging with stalking now.
Flaunting your laws, huh? Don't pull the door on me, you dumb bitch. Don't pull the door on me. You called me a criminal, you dumb bitch. I'll call you whatever I want.
All right, we're back on the record in Gillett versus Hervey, case number 24 DM17. The appearances are the same as stated before. Ms. Gillett, I believe, still under cross-examination. We'll take the witness stand. You continue to be under oath. And Mr. Baker, once she's settled in, you may begin.
Thank you, Judge.
And Judge, you have the exhibits if he refers to any.
Is there particular ones that you need to have out?
Ms. Gillett, you mentioned that you didn't think Dr. Spees had violated the statute, the stalking statute, and that's why you didn't pursue any claims against him. Is that correct?
That's correct.
In that Walker motion, you did want lots of different relief against Mr. Hervey and Lawrence Accountability and Dr. Spees and the other media people, right?
Anyone not complying with local rules.
In terms of those, you wanted relief against them.
I wanted them to not videotape the trial.
You wanted the relief that you stated in that complaint, yes?
It's a motion, and there's lots of relief requested there, including increased court security
I got
and
it.
other issues.
I got it. So this will go a lot faster if you just tell me yes or no, and I don't have to keep asking the questions. So I'll do my best to be direct if you'll do your best just to give me straight answers. Will you do that for me?
Then I'll start objecting as misconstrued questions.
All right. And in that Walker motion, you wanted them to be fined, Mr. Hervey, expenses for change of venue. You wanted them restraint of speech. You didn't want them to be able to publicize. Is that correct?
There's numerous reliefs in there.
As far as what I said, are those things correct?
I don't know if it was specifically them fined, but the defense and or parties violating.
I can read it for you if it's going to be an issue.
Counsel, D has been admitted. I can read the motion.
Okay, and all I'm saying is we're just going to get to the next set of questions. You knew what they were talking about when they walked up to you on July 29th talking about those charges.
Where?
July 29th. They talked
Those-
about the video, the incident, where you say they're yelling and screaming profanities at you, and they mentioned that you were lying about the charges. You knew what they were talking about.
No.
And you have no idea about any charges that are being considered against Mr. Irving?
Anything that has been turned in, I am not making charging decisions on.
Well, that's not my question. You understand that he's being investigated on some charges.
He is.
Okay, and you're aware of that, and so when he referred to the charges, you don't know that he was talking about those charges that are being contemplated here in Elk County.
He repeatedly said he wanted to know if he was getting arrested.
I'm asking you.
That's all I knew is what he was asking about.
Let's just get past it. You had no idea when he said charges, you had no clue what he was asking about or talking about then. Is that your testimony to the court?
I knew that Deputy Love was going to send over affidavits, and that's it,
Okay, about some charges.
about him. It
About
doesn't matter whether
misdemeanor.
it's a charge or whether it's an affidavit.
Okay, and that is a foreplay to a misdemeanor disorderly conduct, right? Citation, right? You're aware of that one?
Officers don't charge. They request charges.
You're familiar with the request to charge Mr. Irving with a misdemeanor disorderly conduct then?
I knew one might come.
Arising from the July 29th meeting, correct?
The July 29th meeting is what they were asking me about. That's
So now you
when
know.
they were asking me.
So the charges that he's talking about referred to this misdemeanor citation that had been submitted to your office.
Okay, I'm confused because you're kind of like mixing stuff up.
Okay, don't worry about it. Let's just move on.
Okay.
You don't know, so let's move on. July 29th, we're looking at Exhibit A, and we're looking at, you said that July 21st, rather, and we've gone through that, and then you said that one counted, that met the statutory requirements for stalking, correct?
Can we pause for a second?
No.
Judge, these are your notes on the petition. I think they're backwards.
Can the bailiff get those, please?
I don't want to look at anything the judge wrote.
Okay, yeah, this is my copy of the, working copy of the petition where it's some highlights and underlining, so.
Is that the petition up there on the bench?
I believe that, if it's A, I think I gave that to council, and I may have given it to you.
A, you got A.
No, there's not an A up here.
Those are the emails.
I got the emails, okay.
That's A. You got the emails, that's all.
Okay.
All right, so we're back. July 21, you say met the requirements for a course of conduct, correct?
Yes.
The next event in your complaint, in Exhibit A, is a August 18, 2024
Yep.
email, correct?
Yep.
And in that email, are you saying that met all the statutory requirements that are stated in that statute?
Well,
Yes or no?
I'm going to object that that's like misleading question.
Okay, well, you're the one that claimed this was an event. I want to know, and an event has to contain certain statutory elements. You know that, don't you?
It does.
So this August 18, 2024 email does it contain all the statutory elements to constitute a course of conduct under that statute?
It doesn't have to mean every single little one.
Does
It can
it
be
mean-
one.
Counsel, hold on, excuse me. Isn't this a rule, something that the court will need to determine if it meets that test?
I'm not asking about this. I'm going to be asking the question is, once we get to two, we've got two course of conducts that she thinks meets the statutory requirements. Then I'm going to ask another question. Why didn't you file? So that's why I'm trying to get to it. And if they don't meet it, Judge, why are they listed as events in the complaint?
All right.
So, August 18th, you're going to say it doesn't meet all the statutory elements.
I'm going to say it meets some of the statutory.
Well, let's answer my question. It doesn't meet all of them, does it?
It's responsive.
Okay.
Move on.
And which ones does it not meet the requirements?
Well, it's not a physical, it's a verbal, and it does have some verbal threats in it that would meet the verbal threat.
Which one? That puts someone in apprehension of fear?
Yes.
What statement is in there that puts someone in apprehension of fear for your life?
Why does he send it to me? Not a good strategy. Videos are a spotlight. Shield against illegal arrest. Conspired retaliation. There's all kinds of stuff. It basically is a rant from him.
Okay, and you think that puts you in fear of your life?
Is one of the elements.
You think it puts you in fear of your life?
It makes me in fear of bodily harm.
And you think those statements then would cause a reasonable person to have substantial emotional distress?
I think that it causes
No, that's my question.
heightened.
You're not answering my question. I ask if it would cause someone of a reasonable person to suffer substantial emotional distress. Yes or no?
Yes, coupled with everything else.
Well, coupled with what else?
Physical action that follows it.
In this email.
The physical action that follows it.
Yeah, I'm not asking about the other stuff. This one event that you say, standing alone, which you said was an event, you say it doesn't meet all the statutory requirements, correct? It doesn't meet all the statutory, correct?
Objection, okay, hold on. Counsel, we keep seeming to go over the same territory. Obviously, it's a course of conduct. The witness can testify as to how she felt, whether or not that is appropriate or should be a reasonable standard is really for the court to determine.
Well, Judge, here's the thing. I think I'm entitled. If she says, and she listed each one of these as a course of conduct event, each one stands on its own as being sufficient. You got to get two. And so now she's saying, well, it doesn't contain all of them. Well, why did you list it as an event then if it doesn't meet all the necessary elements? And then I'm trying to say, well, which ones it didn't meet. So, and the whole thing is here, you've got a chronology. She says, well, I've got all these events, and I got 4 events, and I still haven't filed one. Okay? Why? If you're so terrified, why?
Hold on. I think it's fair in regards to asking what events that she did. Trying to go through everything that it's not will take forever.
Well, and that's my, yes, it is. And so I'm trying to, we've already cut out 2 that she says don't meet. We've got 1 now she says it did. We've gone through that. This one she says is incomplete. I guess I can leave it at that if no one's curious. But, okay, so this one doesn't meet all the statutory elements. So, okay, let's talk about another email. We've gone through 4 events. Let's talk about April 18th, the next one. No, I'm sorry. Let's talk about September. September 9th. There's a September 9th email. Records received today. You see that?
I do.
And it's to, who's Paul Dean?
Paul Dean's the county counselor, and he's the assistant in Greenwood County. He does the traffic only on Fridays twice a month.
And all these email addresses are all official email addresses
They are?
of county officials, correct?
Yes.
Including you.
Yep.
So, are you claiming that this email meets all the statutory requirements of a course of conduct? That would be a yes or no.
Yes, the last line.
Yes, it does?
Yes.
So tell me where in this email where it causes a reasonable person to suffer substantial emotional distress. The language is quoted.
Because he had already physically assaulted me, yelling about ducks all the way up the staircase, so bringing them up again makes another threat through
Hold on.
two
Hold count,
prior thing.
please. He asked what section here? So
The
you,
last section,
which is what?
where it says, "and Jill."
Okay.
So read the sentence you say causes a reasonable person.
Objection. The judge has already said not to read them. He can read them himself.
I just don't know which one it is. Is it the last verse, it says, Jill, I really do have a lot of questions about your obsession with ducks. Is that the sentence you say would cause a reasonable person substantial emotional distress?
It does.
Okay. And that would put someone in physical harm of their safety. You think that too?
This is to be subjective from my point of view, and yes.
Okay. Yes, okay. And so now we've got two events that you say meet the statutory requirements. How come you haven't filed for a stalking injunction?
Because the behavior continued after this.
I thought you were scared. I thought you were terrorized. I thought all those things were happening, and you've got two of them.
Oh, one question at a time. If you're going to ask a question, one question,
All right.
and answer.
All right. So you're telling me you had enough to file, but you didn't do it, right?
Absolutely.
Okay. And so, and then now we go to the, and you don't think he has a legitimate purpose in asking you about a duck?
Nope.
Because
It's not his business. It's my personal life.
even if you stole the duck?
Did not steal the duck. It's been explained.
I know you say it has, but if you had stolen a duck, or the police come to your house about a duck, that's a matter of public concern. You'd agree to that, don't you?
Nope.
Okay. Let's go to September 26th. Let's go to the September 9th meeting. And you've already described that, right?
Yes.
And let's go then now to the September 26th email. You say that meets this email, somewhere in this email, it causes a reasonable person to suffer substantial emotional distress?
Absolutely.
Okay. Is it some parts or all parts or which part?
Several parts.
You want to identify them for me?
The title alone is "The Catalyst is You."
Which one? Oh, that one? Catalyst of what?
You ask your client. It
No, I'm
could be
asking
taken-
you, what did you
It could be
interpret?
taken a number of ways.
I get it. What would that cause emotional distress about? A catalyst of what?
He's blaming everything that has to do with Robert Walker's case, all of his behavior, on me instead of himself and his own behavior.
Right. And you can't, that's not something a county prosecutor can hear? Yes or no? You can't hear
Combined
that?
with a physical aggression against me, yes.
That statement right there, just him standing alone,
Yes, subjectively, to my point of view, yes.
county prosecutor shouldn't be able to listen to that kind of stuff, right?
No, I see it all the time, but this is different.
Okay, so you see this language all the time, and standing alone, that wouldn't cause substantial emotional distress.
But
Right.
subjective to him physically having contact with me, it does.
You'd like to tack on something else that happened outside of this one event, and you say, well,
It's a course of conduct.
let
Part
me,
of the course is the prior conduct.
You said this email was a course of conduct, right?
It's one event. The course of conduct is all of them
didn't ask
mashed
that.
together.
All right, here we go. And of course, each one that you've identified here in the email, you say that that would seriously alarm, annoy, torment, or terrorize you as a prosecutor and the chief law enforcement officer of Elk County, right?
His course of conduct does, and I think it's intended to.
Okay. In the July, in the complaint, it's either in this complaint.
I don't have it in front of me.
Hold on, you identify Robert Desmond.
Yes.
That name sound familiar?
Yes,
You say that he made a physical threat against you?
he did.
And is that something that you're saying Mr. Irby is responsible for? That'd be a yes or no.
Kind of in a roundabout way.
Kinda. And you say because, and you're not saying that Mr. Irby made that threat, you're saying Robert Desmond made that threat.
He did.
Okay.
He's a follower of theirs.
I see. And so anybody that reads a newspaper ad or a newspaper story, in your world, they can be attributed to the author of that newspaper.
No, but I think you can incite violence. That's what the president was charged with.
Oh, I see.
Mm-hmm.
All right. And so, okay, you might just hold on. And you didn't file anything against Robert Desmond, did you?
Do I?
Robert Desmond.
Have I charged him?
Have you done anything about him?
No.
Why? He's the one who threatened you.
I don't believe he lives close enough to harm me, and if he traveled this far and he did, then that would be up to my security to take care of him.
Well, when these emails came in, Mr. Irby was somewhere else.
He comes here frequently.
Okay, I got it. And you said in the Walker motion that the officials received. There's no doubt in your mind that you're receiving these emails as an official.
Some of them not.
They went to your official email address, right?
Hiding something through the official
They
email
went-
is
I'm sorry.
not.
Counsel, hold on. This has been gone over and over and over in regards to this being her official email. We've covered that ground many times. Let's not keep rehashing that same thing. If there's evidence of something else, then please let's get to it.
Well, she was going to tell you it was private, even though it went to her official. But okay, let's move on. And you realize the issue of possible criminal charges against Mr. Irby is a legitimate reason for Mr. Irby to come to the courthouse to ascertain what the charges were or if they're being brought.
It's a legitimate reason to come check it, to see if it's filed, but not to
I didn't ask-
personally attack me.
Didn't ask that. When you filed this motion, November 1st, Lawrence Accountability was following and publicizing things happening in the Walker case, right?
They are.
Excuse me. You said November 1st. There's a motion in the Walker case, and then there's the petition in this case.
Yes, and this petition was filed November 1st,
So it's a petition in this matter.
That's what I'm saying.
Okay.
So prior to the petition being filed in this case, November 1st, you were aware that Lawrence Accountability was publicizing lots of things about you and the Walker case.
I
correct?
am.
You were.
Yep.
And in the Walker case, well, let's strike that. So we've identified numerous events that you have said met the statutory requirements, but you still didn't file your complaint until November 1st,
Yep.
correct?
Yes.
And one of the things that happened in the Walker case prior to November 1st that you got bad publicity on was a thing called Bill of Particulars, in which Judge Rick said your work was sloppy. Isn't that correct?
That has nothing to do with this and is irrelevant.
It's
Answer the question.
He actually said my staff's work was sloppy, not mine.
All right, that's responsive.
okay. And he also then, you didn't get that Bill of Particulars in time, correct?
That's correct. I was in a jury trial.
And he then said count 1 on the disorderly conduct, it got booted from the case.
Objection relevance.
It goes to the timing of and why you're doing what you're doing.
Overruled. You may answer the question.
It has to do with the email received by Mr. Araghi on October 30th.
It has to do with the fact that when that happened,
Nope.
hold it, let me finish. You got this bad ruling, you got embarrassed, and they publicized it prior to November 1st, and that was the straw that broke the camel's back, wasn't it?
Nope. It was
You
an
filed
email.
on November 1st, after that happened, after they publicized this, didn't you?
Nope.
You did file this on November 1st after they published that, correct?
I filed it November 1st after he emailed me on October 30th, and I received it November 1st in the morning when I got to work.
And and you keep up with that because you were aware of that publicity that was being sent out about you.
I don't watch any of their stuff. It was the email that was the trigger.
I see. You don't know anything about his live streams? Is that your testimony? The things that they were, the media was publicizing about Walker? You're saying you just didn't know?
I don't watch it.
You didn't know?
Period, ever.
Didn't say you watched it, you knew about it though. Somebody may have told you.
Nope.
Okay? So you just were completely ignorant of the things that were being publicized through Lawrence Accountability. That's your testimony here today?
Yeah, I don't care about their website.
I thought you were aware of it. And that's why you said, hey, they're public. Okay.
Asked and answered.
Okay.
Sustained.
Now, you filed it on November 1st, the electronic filing. If I see it here. Says it was filed at 4/24/2024, November 1st, right?
Yes.
Where were you when you uploaded that?
His petition, at what time?
4/24, November 1st. It says you uploaded it. Where were you?
I think I was in Greenwood County.
At the courthouse?
Mhm.
Okay. And you use courthouse facilities to do that?
I used my office.
That would be a courthouse facility, wouldn't it?
I was in my office.
Yeah. Your county office.
Yes, I'm an elected
Okay.
official.
And you can't upload unless you have a bar number and you're in the system, right?
I used my personal bar number.
Yes. And pro se litigants can't do that. They can't just, unless they are registered in the system, they can't upload documents into the system, right?
They can if they apply for an account, yes.
That's right. So when you used that, where did you, the motion that you made, where did you create that at?
Well, the motion is filed in a criminal case, and I did that in my official capacity.
The motion for this case. Where did you,
There isn't a motion in this case.
the petition?
The petition in this case was written by myself on my personal time,
On what equipment?
on my laptop.
That's owned by the county.
The one laptop, yes.
Okay. And did you do it all in one sitting, or did you do it over a period of time?
A long period of time.
And that was on that same laptop?
Yes.
And so you're saying that, when did you think you first started drafting this petition?
After the, it wasn't after the physical grabbing the door.
That's July 29th, right?
Yes, it was after the physical grabbing the door.
July 29th.
It was probably around August 15th or so.
What makes you say that, August 15th? Why that date?
It was somewhere in the middle of August.
So by August 15th, you're drafting a complaint, and so you're working on it, you're putting it together, you got plenty of time, right?
Yes, I was trying to gather up all the emails that he had sent me.
Up through August.
Yeah.
Okay. The summons wasn't issued until November 4th. Why was that?
We send those to the sheriff's office when it's a PFA. It goes directly from the court to the sheriff.
Who's the we?
Well, the clerk's office does. They send it over to the sheriff to have service done on it when it's a PFA. So it's whenever the sheriff gets it from the clerk. I have no idea. I don't control any of
The
that.
fax banner says Aaron Mendo, that's the clerk here,
Clerk of the district court.
and so it's faxed from her over to Douglas County.
It would have been, yeah.
How did that happen?
I have no idea. I'm not a clerk. Well, used to be, but I'm not now.
Now, and so, did you personally tell Mr. Irby that if he follows you, it could lead to stalking?
I did.
Okay. But at the point you told him it could lead to stalking, it hadn't actually resulted, correct?
Nope. It was an actual warning to let him know to stop being physical.
Now, and you know Mr. Irby always has his phone on him.
He does.
He's around you. So anything that you say he said is going to be on that phone, right?
It is.
Okay. And you say on page 4 of your sworn complaint that he knows that in person you told him that he was following me around, that it could lead to stalking.
Yes.
And when did you tell him that it could lead to stalking?
When he followed me to the elevator from my office.
What date?
That's the first instance.
July 29th.
Yeah.
Okay.
In July.
Now, you indicated that in your motion, you seem to indicate that the media has to quit asking you questions if you say no comment. Is that what, did I understand that correctly?
I don't know that they have to stop, but the continued harassment is inappropriate when they've been told no comment or I'm not commenting on current pending investigations.
So in your mind, if the media says you say no comment and they just keep asking you questions, you think that's stalking?
I do sometimes in a way.
Okay? And that's what you're alleging here. You're saying I said no comment and they kept asking you questions. You said, you're stalking, right?
It's the course of conduct over months.
Got it, but just in that event, you told him no comment, and you said, I told him no comment.
Object is asked and answered. You ask the same questions a lot, and I've answered this question multiple times today.
Okay, so anything else, because he didn't take your instruction and continue to ask you, you thought that was stalking, correct?
Asked and answered.
You think it was stalking?
Asked and answered.
All right. And you realize that the media doesn't have to stop asking you questions if you say no comment. You realize that, don't you?
If they think that that's their right, they can, I guess.
Yeah, it'd be a legitimate purpose, wouldn't it?
No.
Okay. And, you said in there, he continues to message me with no response from me. And you're talking about the emails in your complaint, correct?
Yes.
You're not talking about text messaging, right?
No.
He never text messaged you. He never called you on your personal phone. He never showed up at your house, right?
I don't know if he's been to my personal house.
To your knowledge.
To my knowledge, I have no idea.
So, and he's never emailed you on personal email, anything like that, correct?
Counsel, you've asked this.
Okay, I'm sorry. So let's talk about the duck. You said that in your complaint, Mr. Irby or his associates, and you're talking about what, the media, the Lawrence Accountability,
One of them.
have contacted someone You said that, but you don't know, right?
I don't know who they talked to.
You don't even know if they talked to anybody.
I don't know how they would otherwise find out about a baby duck that was trusted to me to take care of.
All right, but you have no personal knowledge. You're just connecting dots, and you're just speculating.
Absolutely.
Okay, thank you. And then you say that from the Fredonia area to try to gain personal information. And that's pure speculation, because you don't know.
The only records at the Fredonia Police Department.
You don't know what they said or did with other people. You have no personal knowledge of that, do you?
Nope.
Now, and this personal information that you say was what? That you had a duck?
They keep alleging I kidnapped a duck, and that's not true. It's a false statement.
The personal information that you're alleging is about this duck. Is that correct?
That's one piece of personal information.
Okay, well, let's just keep it on the personal duck thing. September 9th, you said he brought up the duck incident. Family made a report their duck was missing and it was returned. You said that, right?
Yes.
You would agree that the chief law enforcement officer of L County, the county prosecutor, has got somebody's duck. That could be stolen property.
Not to my knowledge.
Really?
It wasn't to my knowledge.
You didn't own that duck, did you?
I was called to render aid as a person who takes in animals.
Object is non-responsive. You didn't own that duck, did you?
It was not mine. I was fostering.
Thank you. Correct. You didn't own it. You got the duck, and somehow police showed up at your house about a duck that you did not own, correct?
Already been testified to. Objection.
Answer the question, please.
The police showed up to ask for the duck.
Yeah. And that's a matter of public concern, that you got a duck you don't own, and it belonged to somebody else, and the police have to come out and get it from you. You'll admit that.
It isn't public concern.
And that, how did they, the duck that you didn't own, how did they find you? Do you know?
I do.
Okay.
I made a post on Facebook that a baby duck was lost. It was trusted to me, and if anyone knew about it, to let me know,
Fair enough.
because I am a rescuer,
Got it.
and I can even be contacted by the Department of Parks and Wildlife to do their rescue.
I got it. All right. In any event, the police came, did they take it directly from you?
Yes, I gave it directly to them.
And then they put it in the car or pickup and took it back to the owner, right?
Oh, yeah, absolutely.
And so, and then, so Mr. Irby, when he says, hey, I want to know about that duck,
Not any of his concern.
it's not a legitimate purpose in your mind.
No.
And did that cause you substantial emotional distress that he said, hey, how about that duck?
Yes.
And did that cause you to be in physical apprehension of harm, physical harm to yourself, that he asked you the question about the duck?
It gave me concern of harm of him prying into my personal life, yes.
Physical harm is what I said.
I am afraid of physical harm from him,
From that, asking the question about the duck.
from the course of conduct.
I object is non-responsive.
Yes, it is. Move on.
All right. And then you say something about slander and libel.
Are you talking about the petition or the motion?
I'm talking about your petition. I think you bring out one or the other, don't you? Where do you talk about slander and...
Yes, he's screaming in the courthouse that I'm a duck kidnapper when I rendered aid because a little boy brought a duck to someone else's home and said he found it, and they were concerned about its care and well-being until we could find out if it was wild or not. And he's screaming through the courthouse that I'm a kidnapper?
It's non-responsive. I mean, you just give it a name.
Yeah, it gives me concern.
What is the elements to defamation in Kansas?
It has to be untruthful, which it is.
Anything else?
It has to try to damage the reputation, which he tried to do in the courthouse.
Okay. It has to be a false statement, right?
It is a false statement.
And you're saying he made by asking you the question about where's the duck, that's a false statement?
Oh, yes.
In the complaint, maybe it's in the Walker complaint. Did you complain about,
The Walker complaint is not part of this, and I'm going to object to relevance. You keep bringing it up, but it's not relevant in this case.
you bring up the same issues in the Walker complaint that you...
Well, hold on. What's your question? She made an objection in regards to relevance. So your question again, please?
The question is, you made allegations of slander and libel in the Walker case.
Objection, it's not relevant to a course of
Overruled.
conduct.
Answer the question.
I don't remember if it's in there or not. That's been clear back in July. A lot of water goes under the bridge, and my sister died, and I've had a lot of trauma since then.
Okay, so you don't remember if you made that allegation. And so one of the things you claim in this petition is you claim that he defamed you or slandered or libeled you, and that's a basis to obtaining the relief in this case.
No, it's a separate issue.
But you're claiming it here, are you? Or are you?
It's an issue that he's prying into personal things.
Are you?
And misconstruing them.
I'm going to ask you a yes or no question. You've raised up slander and defamation and libel. In this case, are you claiming that is a basis for the relief that you're seeking in this case? Yes or no?
Course of conduct.
Non-responsive. I'm not asking about course of conduct.
I'm going to overrule the objection. You can answer, is the claim of...
It's part of it. I would say yes, it is part of it.
Forms a basis for your complaint.
Part of it. Part of the complaint of course of conduct.
So, November 1st, did you take a day off when you worked on that and filed that petition?
No, elected officials are different than employees. I don't know if you understand that.
I didn't ask all that.
I don't have to take a day off to work on personal things.
Didn't ask that. I just asked you if you took a day off, yes or no?
No.
Okay. And you're not taking a day off to do this little hearing either, are you?
Unfortunately,
No.
because I don't have to write it down.
Got it. All right. No further questions.
All right. You may redirect.
Oh, there's a lot there. Elected officials are always on call. As the county attorney is on call 365 days a year, 24 hours a day. Even when I go on vacation, I receive calls from deputies very frequently, and I answer their questions. So, no, we do not take time off. We are salaried. We are required to work 7 days a year or something like that, 12 maybe. I work 5 days a week, and I rarely get to take time off. I have appeared from almost every vacation I have taken since becoming county attorney. So no, we do not get to take time off. So even today, I am on call. If there was a homicide today, I would have to leave and go to the scene if I'm asked to. And I do, and I get up in the middle of the night, and I spend evenings helping with search warrants and rape investigations and homicide investigations, a multitude of different kinds of investigations. I've spent nights up till 3 o'clock in the morning, spent all-nighters with my officers because I am a very active county attorney with them. With that being said, no, we do not take a specified day off because I am never off, the same as the sheriff. As that is said, When it comes to the issue of the baby duck, I've already explained what happened. It was entrusted to me by individuals to keep. Messages were sent out to see if they could locate the lost baby duck's owner, or if it was a wild duck because of its breed. I raise or can be trusted with birds that are even migratory if they're injured. I have calls of people asking for.
All right, now, I would ask you to keep the redirect to things that haven't been testified to. As you noted,
Okay.
you've testified to this.
Now, it is a course of conduct, and the conduct totality with multiple events is what added up. I have
Yeah,
testified.
those are legal conclusions, but
Sustained.
He asked me about whether or not Sheriff Walker gave me anything before the hearing. The answer is no. He is subpoenaed ducis tecum with items.
it's been asked and answered. It's just,
Yes, sustained.
With that, when I asked Sheriff Walker for specific videos, he did call to have a narrowing of that time frame, so I gave him the narrowed time frame. He obtained the videos that he had access to that I asked for in my subpoena and brought those with him to court. I, as an attorney, try to keep what is personal and official as much as possible separate, which is why a special prosecutor is asked for. So, no, I never had access to those videos, and no, I do not have access to the court system. In fact, someone once has broken into my office here at the courthouse,
object is irrelevant.
and I never looked into it or was able to look at it. So no, I do not access the court cameras of the courthouse. Trying to think of what else I needed to. On the Walker motion, you asked me several things. There are things that Judge Lee can look into in that motion. Most of it is heightened security, and if there is a change of venue, which Gary House was asking about, then I was going to ask, and it's in there, that if there's any change of venue, the cost can be charged to the defendant or anyone causing the change of venue. So that is part of it, and a big chunk of why Lawrence Accountability and Kansas Freedom News are discussed, and it's discussed about other individuals making threats towards us that are followers. We have had a big long list of derogatory names, some of which are hate speech, referring to Nazis, that have been called in by other individuals, and that's why none of that is alleged in the complaint, because it's not Mr. Araby making them, it's his followers. And I did not allege any of the incidents against the other officers, such as driving by their homes, because again, that's not directed to me, it's directed to individuals surrounding the case. And so I did not allege those. I kept it strictly to his actions against me, and that's why I feel the motion is not relevant in this case, because I narrowly tailored the incidents directed
Argument.
at me.
Objection, he's just making an argument.
Sustained.
I'm explaining why it's so narrowly tailored. I do not want any of the emails that he had back and forth with me to be like, oh, well, we had this email and it's not whatever. I want the judge to be able to see all of them and the complete evidence, which is why every email is included. The course of conduct heightened for me at the time that he caused physical contact with me. And I have thought all along that he would not be able to control his temper to the point that he would either lunge at me, hit me, hurt me, or bump into me. And his closeness in proximity to me, I knew at some point he would come into physical contact with me because he has a hard time to control his temper. And that is why the course of conduct added up to the point that he got so close he yanked the door out of my hand.
That concludes the redirect.
Yes.
Recross.
No further questions.
Thank you. You may step down.
May I approach, Your Honor?
With the exhibit. Thank you. Does the plaintiff have any additional evidence?
The plaintiff rests, Your Honor.
Plaintiff rests, defense?
Judge, we'd like to make a motion to dismiss, close of that evidence.
You may make your motion.
And Judge, I've written, got a couple of things that,
Is he planning to file this as part of the court file?
I haven't been given anything.
I will.
I'm entitled to 7 days to respond to the motion.
This is a motion at the close of evidence.
All right, you make your oral motion.
Judge, I'm going to hand you also, for your edification, I marked it as Exhibit F, but it is this Logan case, and I'm going to refer to it in this motion.
Okay, this is not a case that was cited earlier.
It was, but I'm going to track through it, and just for the court's edification, I've got some things highlighted that I just want to point out to you. So it's just for the court's edification.
All right. The court's been handed a document that's entitled Motion to Dismiss.
If you're handing the highlighted case to the judge, I need a copy.
You got it.
Which is a 9-page, well, the signature of Mr. Baker, well, actually it's not, it's electronically signed. So was this filed with the court then or not?
Not yet.
Okay.
Not yet.
Right. And plaintiff has a copy of this now?
Yes, it was just handed to me.
So, Judge, you basically heard the complainant. She's basically said this, that she has this subjective idea about what will harm her, and she's just added up all the contact she's ever had with Mr. Irby. And then she's just tried to connect all that. I've handed you the Logue case from Florida, and I've also cited a Kansas case, but in the Kansas Cindy case, the lower court was overturned, and the appellate court said, look, there was a legitimate reason for the parent to contact the child, even though the other parent didn't like it. You're not going to find any cases, they're rare, where a public official tries to get a stalking order against media or something of that nature. It is just doesn't happen. The Logue case is one of those rare cases, and that case was a state senator, and she asked for stalking, a ruling, and the lower court gave it to her. The Court of Appeals reversed it. And so I'm going to kind of highlight what it is that when they looked at that, you can read, it says that she's a public figure. And on page Page 7, I've highlighted, their statute is identical to Kansas.
Okay, now you're referring to
I'm referring to Exhibit
Florida case?
F, yeah, the Logue case. So page 7. And I've highlighted, it says injunctions are not available to stop someone from uttering insults or falsehoods. Well, she wants this injunction to stop insults and falsehoods, even if, and she hadn't even proven falsehoods. Let me just say this. She claims that asking about a duck is defamation. It's ridiculous. A remedy is not available to prohibit defamatory or libelous statements. The reason for this is there's an adequate remedy at law, an action for damages. Merely foisting insults, as Respondent did in this case, is not defamation. Now, the only thing that she ever said, he said, which is out of that July 9th or 29th video, which he said, you're bitch. Now, she's already behind the door, and you ask a good question, and just remember this, Judge. All these contacts she says, put aside the emails, because that's almost, we'll get to that. But all these contacts that she says are there, they happened in the public. They're entitled to be there. They're the media. And when she says, oh, they yelled and screamed profanities, you've got the video. They weren't doing any of that. They didn't scream and yell at her going up the stairs. And so when she closed that door, he, of course, yes, I opened it. He did call her name. You know what? When she went into her office, they stopped. And the same way, when they went to the elevator, she had Joseph Love there, Deputy Love, and she was there, and she's telling him, hey, you can't record here. But when she went into that elevator and closed the door, they didn't follow her. They didn't do it. The idea that they did something to violate or intrude upon her, the public, is just absurd. But even what she describes is, she says, well, my address is private. She's a public official. It's already out there. Her car's parked up there. I saw it. You saw it. Everybody sees it. It's public. They go into it. Page 7. Conduct that serves no legitimate purpose. Legitimate purpose is given not only comport with common sense, but must also comport with, let me read this, with any lack of usefulness or utility. Now, she's not being, there's nothing here, they're coming to your house or all that. This is all official business. It's strictly official. Everything they did was emailing, coming to a public meeting, open meeting, all that. It's all something of public concern. The media would be very interested in a duck that ended up at her house that was, stolen, whatever. But the fact that police show up at the county prosecutor's office and they have to take this duck back, that's a matter of public concern.
Objection, that's misconstrued. Not my public office.
This is argument. I'm going to permit him to make his argument.
So and she's a chief law enforcement officer. So, and just to say, hey, I just want to know about the duck, I know it's embarrassing to her, but you can't manipulate the court system in a way that says, well, now that, you're embarrassing me. Injunctions are not, on page 7, it says whether a communication with a legitimate purpose is construed broadly and will cover a wide variety of conduct. So as the media, which she says wants accountability, and they all are, they have an interest in what this prosecutor is doing. Let's talk about the other thing. They got charged. Somebody somewhere, that Joseph Love said to them, hey, we're charging you out of that July 29th meeting. We're going to cite you for a misdemeanor. Now, put aside that, think about what happened in the Walker motion. She was wanting ex parte relief against people that you don't have any jurisdiction over. And she wanted them fined, prior restraint of speech. I mean, monumental things. I think that was totally frivolous. You don't have any personal jurisdiction over these individuals. So when they find out about that, of course they're going to talk. They're not just, interested in Miss Gillett's personal life. And then you come to the other charge where they say, we're going to charge you on this other thing. They're swinging a big bat here against them. And they're trying to shut down negative publicity.
All right, hold on a bit. you keep using a plural, they and them. And.
Okay, this,
There's,
I say this, Gillett. Jill Gillett. And when I say they, I'm talking about all the media, including Mr. Irving and Lawrence Accountability. So that, all this is put all together. On page 8, while a respondent's presence may have made petitioner uncomfortable, he was well within his rights to attend and express his opinion on the film subject matter. Mr. Irving was completely within his rights to attend these open meetings. And the one part where you saw where Ms. Gillett interrupted Mr. Irving, she's not a commissioner. She's running nothing in that meeting. She interrupted him. And so he said, hey, Jill, be quiet. Shoot. He was perfectly within his rights. He had already appeared before the commission prior to that, and he had an issue with the idea that you have to identify yourself to come to the court. That was one of the things there. That's in the early part of that meeting. Later in the meeting...
which wasn't published. It's admitted, but just not played.
That's right.
Okay.
But you'll see he addresses that, right, and then as the meeting ends up, you see him back in the back with his camera. And then that's when she's making a presentation, and that's when he starts talking. She interrupts him. There's nothing wrong with that. And then when she comes out, of course, you saw that. And they said, hey, now that you're here, let's talk about the duck. Why are you lying about us about the charges? These are legitimate reasons. They're not asking about her husband or anything like that, nothing personal. It has to do with all the things that affected them. And that's legitimate, Judge. He made no threats. No threats. None. Now, her idea that he threatened her from these emails is ludicrous. And it is an objective point of view. She actually contends that those emails would cause a reasonable person substantial emotional distress. Nothing. A core request? 2 core requests? He emailed all the officials. You know, if he was trying to be stealth or secretive, he wouldn't have done that and done it with, he CC'd everybody. He CC'd state representatives. And so here she is, she says, well, I don't like the fact that he said he's going to follow my career. Well, she's got a professional career. She's a public official. Yeah, I'll follow you. You're not entitled to that kind of privacy. She said in her motion, you've got to have thick skin. Well, she doesn't have thick skin. And if she doesn't want to be a public official, if she doesn't want to be that, get out of the business. Now, if you read through this, it's an objective, reasonable person standard. And this idea that you've got a public official in the media and they're contacting, that simply blows all of this out of the water. She didn't even, to say that they can't ask her questions. And here's the other thing. She said, you know what, Dr. Spees did not violate the statute. Well, he was every bit alongside Mr. Irving all along. He was right there. He did everything he did. She said, well, the only thing that Mr. Irving did was that one time when he went out and I was walking to my car and Dr. Speed stayed there, but Mr. Irving, he went on ahead. He said that he prosecuted. There's nothing there. I mean, the woman is carrying a Glock right now. She has one in the chamber. All these contacts, they've got deputies here. At the elevator, Joseph Love was there. And she's saying she's petrified. And yet she says, I'm an EMT, I'm trained, I'm a law enforcement officer, I do all these things. And yet she's this fragile. But it doesn't matter what her subjective beliefs are. The standard is objective. Think about this.
Mr. Baker, what do you see as the standard that the court has to apply at this juncture in the trial in regards to your motion to dismiss?
Preponderance of evidence. I mean, there is a preponderance of evidence. I mean, if that's what you're asking.
Well, in a criminal case, you know, at the end of the state's motion on a motion to dismiss, the evidence has to be considered in the light most favorable
That's
to
right.
the state.
And yes. And you can, even if you construe all the evidence you put in, none of it. You look at those emails, you can read those for yourself. They do not constitute anything that would put a reasonable person in apprehension of their physical safety. Impossible. And there's nothing in there that says they weren't for a legitimate purpose, or that they would have caused substantial emotional distress. Nothing in there. So that fails. And then you saw the video, July 29th. He wasn't yelling. He wasn't even angry. You know, she says yelling and screaming. If you would have read her complaint without the videos, you thought we were in a different world. He wasn't yelling. He wasn't screaming. None of that. It all happened outside. And so she played that November 6th, and he said, well, they came up to the clerk's office. Okay, he has a right to come here and ask for records. Oh, but, you know. So there's nothing here, Judge. She doesn't even meet the elements that are necessary. There are no two course of conducts. Even though she listed 9 or 10, right out of the box, she said the first 2 emails don't do it, and you heard her talk about the others. So, you know, you've got public media, and you've got this standard that is a reasonable person, and Judge, there's no way she even alleged it, much less putting the evidence on. What she thinks is private about a duck and the police coming is not, that's public, a legitimate purpose. That's a public concern. And they had legitimate reasons, he did, for asking her, have I been charged? Why are you charging me? What, you know, you asked for all this relief in the walker. What is that all about? And they went to the clerk, they went to everyone. She's a prosecutor, chief law enforcement officer. They have a right to ask her those things. So she said, she thinks that if she says no comment, that, boy, if you cross the line after that. That is not what public officials are entitled to. I mean, you see that all the time on TV. Mr. President, you know, whoever, you know, they ask questions, and they keep asking questions. Now, they don't follow into the helicopter, and neither did they follow into the office. You just saw, they gave her space. When she said, got in the elevator, all that, okay, fine. But you don't see any lunging, you don't see any of that stuff. Nothing. Now think about the relief that she's trying to get. A prior restraint on speech to the media, to him. Don't even come to the courthouse, because this is where I work. You can't even come into the courthouse. You can't attend the Walker trial. You can't do any of those things. Judge, you're just, this road case is right on. I hope you read it. I'm going to ask that you just dismiss this case. The evidence is not sufficient, so I ask that you dismiss it.
Okay. Well, in counsel, I'm going to give the plaintiff an opportunity to respond, but I just want to, at this juncture, how should the court interpret the evidence that's been heard in the light most favorable to the plaintiff? Because this is at the end of the plaintiff's case, or some other standard?
I don't know that you interpret it in the light most favorable to the plaintiff. I think you're the judge of credibility, and you've heard the testimony.
All right.
It's evidentiary.
Okay. Well, I'll hear the plaintiff's motion at this time, or excuse me, response to the motion. But I'm cognizant, and I anticipated there'd be a motion. I wasn't anticipating a written motion, nor was I anticipating a case citation from another state that's now been provided. That wasn't provided earlier, so I will ask if the plaintiff wishes to make a response, and I'll go from there.
Your Honor, I believe when there's a written motion, the individual who the motion is towards has a full 7 days to respond to a written motion. I also was just handed a case from another state, and case law from another state is advisory but not mandatory. I did look up a lot of law that Kansas has, and I pulled up the case of State v. Smith, which is a case that involves a criminal conviction of a woman for violating a PFS. The conviction was reversed, and it has a lot to do with First Amendment, but it's only verbal speech. It has nothing to do with physical. Because when it comes to physical contact, there's a whole different ballgame. That case does give some of the pertinent information on what is and isn't permissible, how Kansas looks at protections from stalking, and what the overall arching issues are. First off, this motion is factually inaccurate. His argument is factually inaccurate. That's not what the testimony shows. This isn't my neighbor's duck. I was not the one who found it. I was entrusted to care for it because that's what I do in my personal life. I actually have a rescue. I have multiple pens. A lot of drakes are eaten or killed or harmed because of issues with duck care. The ratio is 5 ducks to 1 drake. I know all of this. I actually have a bachelor pad for rescue drakes. I know that's a lot for the board and off topic.
Right now, I would like a response in regards to their motion to terminate the case.
This is extremely factually inaccurate from what I can quickly skim. His argument is factually inaccurate. It's not my neighbor. It was a neighbor to the little boy who found the duck and brought it to another's home. And I was entrusted to care for it. I actually posted the missing post on Facebook that helped my law enforcement friends come and find the duck with me and return it to its rightful people. Because I'm friends with many, many law enforcement online, and I have represented officers, and I work with officers every day, both when I was a defense attorney and as a prosecutor. So some clarifying stuff was enacted in 2016 in the Protection from Stalking Act, and those laws kind of delineated what is protected speech and what is not. And communication involving a judicial proceeding, an official proceeding, an official request, those can be made. And I absolutely agree those should be made. He talks a whole bunch about the Walker motion and the Walker trial. I specifically say in there that legitimate media concerns, processes, and everything should be honored. However, not legitimate things should not. That they should not be permitted to be live streaming onto their social media to get ratings and views. Robin Wonderlook is an example. She often sends a request to the chief judge way ahead of time and says, can I legitimately record for my own purposes to help me report on the case in the newspaper and to help me with my notes? And she may not even record all the proceedings, and he may limit her. And I brought that to the court's attention in there, that I am not asking to ban all media, but to have there be no live streaming or things of that nature.
All right. I'll ask you the same question I asked Mr. Baker. What should the test be at this stage of the trial in regards to like, as I indicated, I'm very familiar with the criminal case, the light most favorable to the state or to the plaintiff, on a motion to dismiss, at this juncture, meaning at the end of the plaintiff's case. What do you feel the burden is on, for that motion at this time?
Let me get past this. It's sufficient evidence. I don't know that it says one way or the other if you take it in light most favorable to the plaintiff, but it is a de novo review because this is a criminal case standard, and I don't believe there's like a civil. I read a lot of cases and I couldn't find one that had a civil standard. This may be a case that would be the determining factor, and I think that is a very, very good question. I believe you would apply the civil rules, and I believe Mr. Spees is recording in the hallway through the window. And
Right.
I just turned it off.
All right, counsel, I'm going to take the defendant's motion to dismiss the case at this juncture under advisement. There's evidence that in the form of video that the entire video was admitted. However, only certain portions of it were published. Additionally, there's arguments here, and they may be valid arguments and so forth in that regard, but I want to take up any evidence that the defense wishes to take up at this time in their case in chief. It's 3:15, so I'll take it under advisement.